Thank you very much, Chairman Pearl and other members of the committee. My name is Nino Marchese. I serve as the Judiciary Director of the American Legislative Exchange Council, also known as ALEC. I very much appreciate the opportunity to speak to you today about this bill. A little bit about ALEC. We're America's largest nonpartisan, nonprofit voluntary membership association of state legislators. We have about a quarter of the nation's state legislators as our members. And more specifically, as the Judiciary Task Force Director, I handle various civil and criminal justice reform issues. A big bucket is working on administrative state reform and reinforcing our separation of powers framework. Judicial deference fits perfectly into this camp, and this is an issue I've worked on for several years. Put simply, judicial deference is a judicial doctrine which ties the hands of judges and forces them to adopt the legal interpretations made by executive branch bureaucrats. So fundamentally, our members see this as a contravening of the separation of powers. You have a legislative branch, which is supposed to be the exclusive lawmaking branch, a judicial branch, which is supposed to be exclusive legal interpretive authority. And this deference doctrine essentially forces judges to cede to bureaucrats where there's no democratic accountability to adopt their interpretations into law. So just like the bill sponsor said, Representative Copal, in 2024, the U.S. Supreme Court abolished this practice. For 40 years, it was in place. Now federal courts are prohibited from automatically deferring to agency interpretations. That decision didn't touch state courts, and deference doctrines were all throughout the states, including New Hampshire. Essentially, in the last 5 or so years, we've seen about 13 states having statutorily outlawed deference. We have about 7 states running these bills this 2026 session, including New Hampshire. And it's really just as simple as putting the baseline authority back in the judicial branch. I think it's important to recognize that courts may still end up at the same interpretation that an executive agency may have seen it. They're not prohibited from doing that. They're just prohibited from automatically having to defer, regardless of how they see the law. And so I think it's an important distinction to make that prohibiting this deference doctrine is simply reinforcing the authority that courts are supposed to have to be the exclusive interpreters of the law. In New Hampshire, you do have deference doctrine established at your Supreme Court level. However, you're one of many states that inconsistently applies the doctrine. A lot of states mandate deference be practiced, and that's consistently done. A lot of states simply permit discretionary authority, and then that's inconsistently done. So there's inconsistency in how it's applied. So the understanding of how deference is going to be applied in a New Hampshire court is really a gamble and uncertain at best. So we commend this legislature and this Senate committee and the sponsors involved for introducing this legislation, for considering legislation to prohibit the practice. This legislation aligns very similarly to an ALEC model policy, the Judicial Deference Reform Act. And we commend you all for taking up this important issue. And I encourage all of you to review ALEC's model Judicial Deference Reform Act as you continue to work on this. And I'm happy to answer any questions that the committee may have. Thank you.